This presentation on renter protections in the City of Los Angeles is being provided by the Los Angeles Housing Department as of February 2023. The information is intended only for residential units located inside the City of LA, not for commercial units, and not for properties located outside of the City of Los Angeles, in other cities, or in unincorporated areas of the county. Today's presentation will cover these general topics: how to determine whether the rental unit is located in the City of Los Angeles versus the unincorporated area of the county. What is the City of Los Angeles Rent Stabilization Ordinance? Renter Protections Update as of February 2023. The new City of Los Angeles Just Cause Ordinance effective January 27, 2023. Other new laws and new upcoming laws, and how to contact the Los Angeles Housing Department. It is important for landlords and tenants to understand if the rental property is located inside the City of Los Angeles or outside of it, because different rules will apply in other areas. And today's presentation is intended to only cover rental properties inside the City of Los Angeles. The easiest way to tell if the property is in the City of LA is to look at your power and water bill. If it was issued by the LA Department of Water and Power, or LADWP, then the rental unit is located in the City of Los Angeles. If the water or power bill for the rental unit was issued by a different company, for example, Edison, or a water and power company for a different city, then the rental unit is not located inside the City of Los Angeles. If you're still not sure if your rental unit is located in LA, in the City of LA, you can look it up at a website. The website is neighborhoodinfo.lacity.org. Once again, that's neighborhoodinfo.lacity.org. When you go to this website, you can enter the rental property address. If you get search results, then your property is located in the City of Los Angeles. However, if after you enter the address in the search field, you get a message that says nothing found, then the rental unit is not located in the City of LA. If the rental unit is not in the City of Los Angeles, then we recommend that you contact the County of Los Angeles. The county can be reached at via their telephone number, which is area code 833-223-7368. Once again, that's area code 833-223-7368. Or you could visit the website at rent.lacounty.gov. They will be able to provide you information on the rules in the unincorporated areas of Los Angeles County, some of which apply to other cities as well. Once you have determined if the rental property is located inside the City of Los Angeles, then the next important piece of information that's needed is whether or not that rental unit is subject to the City of LA's Rent Stabilization Ordinance, commonly referred to as the RSO. The RSO is a law that's been in place since 1978 and applies to rental units that were built prior to October 1st of 1978, or if they were built after July 16th of 2007, after the filing of an Ellis Act eviction. These units are subject to the RSO, which means that they have regulated rent increases. This is an important piece of information for tenants and landlords to have because the RSO units have some additional requirements for landlords and additional protections for tenants, which will be discussed later on in the presentation. If you are uncertain if the rental unit is subject to the city's RSO, you can go to the website at cemas.lecity.org. There you will enter the rental property address. You will get search results, which will include a list of different accordions of information, one of which is titled Housing. You can see an image of this accordion on your screen on the right-hand side. Under the Housing accordion, there will be a category for Rent Stabilization Ordinance, which I have highlighted in yellow. If the flag says no, then that means the property is not regulated by the city's RSO. If it says yes, then it is regulated by the city's RSO. You can also text the letters RSO to the telephone number 855-880-7368. You will receive a text message that will ask you to enter your address. The address you enter will then be recorded, and you will receive a message as to whether or not the property is subject to the RSO. Renter protections in the City of Los Angeles that are related to COVID-19 apply to all residential rental units, regardless of whether or not they are subject to the RSO. The City of Los Angeles declaration of local emergency was effective on March 4th of 2020, and it ended on February 1st of 2023. However, there are still protections that apply to tenants for various reasons. First, there are protections for non-payment of rent as follows. Beginning February 1st of 2023, tenants must pay their full current monthly rent on a go-forward basis to avoid eviction for non-payment of rent. However, if the tenant is both low income, meaning they fall at or below the 80% area median income amount for their household size, and the household was impacted by COVID-19, then those units, those tenants, continue to have eviction protections for non-payment of rent through March 31st of 2023 of this year. That means that if a tenant provides to the landlord a notice within 7 days of the rent due date that they are both low income and impacted by COVID-19 for the months of February and March of this year, 2023, then the landlord cannot evict the tenant for those months due to non-payment of rent. For your reference, we have included an income chart for 2022. The income chart shows the total amount of income per household depending on the total number of persons in that household that would qualify as at or below 80% of the area median income. In addition to the city protections, some tenants who also complied with state law requirements in the years 2020 and 2021 have an additional layer of protections from eviction for non-payment of rent. Depending on the time period that the rent is owed, a tenant cannot be evicted for non-payment of rent if the tenant did the following. For the time period between March 1st, 2020 through August 31st of 2020, a tenant can never be evicted for non-payment of rent if they gave the landlord a COVID-related declaration of financial distress. Even though the tenant still has an obligation to pay the amount owed for these months, a landlord cannot take the tenant to eviction court for non-payment of these months. Likewise, for the time period between September 1st, 2020 through September 30th of 2021, if the tenant did two things. Number one, gave the landlord a COVID-related declaration of financial distress and paid 25% of the total rent owed for those months, the landlord can also not evict the tenant for non-payment of rent for these months. Once again, even though the landlord cannot evict the tenant for non-payment of rent for these months, the tenant still is obligated to pay the rent to the owner, and the owner can take the tenant to small claims court for the non-paid rent. Small claims court is not the same as an eviction court. They are different things. COVID-19 rental debt that has to be paid to the landlord does have a repayment period, depending on which months are still owed by the tenant. Tenants who owe rent between the months of March 1st of 2020 through September 30th of 2021 have until August 1st of 2023, this year, to pay the owner the rent owed for those months. For the months between October 1st of 2021 through January 31st of 2023, tenants must pay the rent to the owner that's owed for those months no later than February 1st of 2024. That's next year. A tenant who wishes to report to the landlord that for the months of February 2023 and March 2023, they still are protected from non-payment of rent, meaning they don't have to pay the rent immediately. Those tenants can download a notice of the 7 days that they have to give to the landlord at the website indicated on your screen. By giving the landlord this notice, the tenant is reporting to the landlord that they are both low income and financially impacted by COVID-19 during the months of February and March of 2023. Additional protections from eviction for all residential units in the city of Los Angeles are as follows. For unauthorized pets and unauthorized occupants related to COVID-19, until January 31st of 2024, next year, landlords cannot evict a residential tenant based on the presence of the unauthorized occupants or pets that were necessitated by COVID-19. Additionally, once January 24 hits, a landlord must first serve a tenant a 30-day notice to cure before initiating any eviction process against a tenant for an unauthorized pet or unauthorized occupant. For no-fault evictions for units that are regulated by the RSO, landlords may resume issuing notices of no-fault eviction, such as compliance with a government order, owner or family or manager occupancy, demolition, withdrawal of the unit from the rental market, on February 1st of 2023. However, landlords are first required to submit a declaration of intent to evict with LAHT for all no-fault evictions. Note that there's a special rule for tenants who previously had already been served with a notice to terminate tenancy for a no-fault eviction prior to March 4th of 2020. Those tenants who have pending eviction notices from 4 years ago must first receive an additional 60-day notice to terminate from the landlord no earlier than February 1st of 2023. Specifically, evictions that are based on the Ellis Act cannot be enforced in court until April 1st of 2024. Units that are subject to the RSO have a unique protection in the city of Los Angeles in that the annual rent increases for these RSO units cannot occur until February 1st of 2024. That's next year. Once again, if the rental unit is regulated by the RSO, a landlord cannot increase the rent until February 1st of 2024. For all rental units, regardless of RSO status, late fees and interest are not allowed if the tenant was financially impacted by COVID-19 between the months of March 1st, 2020 through January 31st of 2023. So a tenant who did not pay or paid late their rent for those months, and the reason was COVID financial impact, they never have to pay those late fees. Additionally, if a tenant also meets the LA County requirement, meaning they're both low income and were COVID impacted during the months of February and March of 2023, they have an additional 2 months where they do not have to pay the late fees. And note that retroactive late fees are prohibited for all COVID-19 rental debt. If the rental unit is not subject to the RSO, it may still have regulations of rent increase under state law, known as AB 1482. For non-RSO units only, the rent can be increased right now. However, if regulated by AB 1482, the rent increase cannot be more than 10%. And that is effective until July 31st of 2023. After July of 2023, that percentage is subject to change depending on the consumer price index. So once again, if the rental unit is subject to the RSO, no rent increases are allowed until February 1st, 2024. But if it's not subject to the RSO, then rent increases are allowed to no more than 10%. A very significant change in the laws in the city of Los Angeles is the Just Cause ordinance, which became effective January 27th of 2023. Under Just Cause, all residential units in the city of Los Angeles that are not subject to the RSO are protected under the city's Just Cause ordinance. However, please note that Just Cause ordinance protection applies after the expiration of the initial lease or after 6 months of continuous occupancy of the tenant in the unit, whichever comes first. Just Cause ordinance is very similar to the RSO in terms of the eviction protections it offers to tenants. It requires a legal reason in the same way that the RSO does. It contains at-fault and no-fault eviction reasons in the same way the RSO does. At-fault eviction reasons include things such as non-payment of rent, subject to the COVID protections, of course, lease violation, nuisance, illegal purpose, such as drugs and gangs, failure to renew a similar lease, denial of access into the unit, and a subtenant not approved. No-fault tenant evictions include evictions for the purpose of owner, family, or manager occupancy, evictions for the purpose of demolition, withdrawal of the rental units, or substantial remodel of the units, compliance with a government order, conversion of the unit to an affordable housing development, and conversion of a residential hotel. And finally, if the property is owned by HUD and it will be sold. These are the legal reasons to terminate tenancy, which are identical to the ones under the RSO. In the same way that the RSO requires relocation payment for no-fault evictions, the Just Cause Ordinance also requires relocation assistance. The amounts of relocation are shown on your screen, and be aware that they are the same amounts as under the RSO. However, because the Just Cause Ordinance applies to single-family dwellings, these single-family dwellings have slightly different rules in terms of the amount of relocation a landlord must pay to a tenant. Evictions for single-family dwellings where the property is owned by a natural person and that property owner owns no more than 4 dwellings on a lot and 1 single-family dwelling on a separate lot, requires lower relocation payment of 1 month's equivalent rent. Similar to the RSO, the Just Cause Ordinance also requires that the owner files a declaration of intent to evict with LAHD. Another new requirement in the City of LA that applies to all residential units, including RSO and Just Cause and any other unit that's rented in the City of LA that's residential, is that landlords must file a copy of the notice to terminate tenancy with LAHD no later than 3 business days after service of the eviction notice on the tenant. Currently, we are accepting filings of notices for at-fault reasons, which can be filed online using our new system found at housing.lacity.org/eviction-notices. Using this online system, a landlord or their representative or their attorney may file a copy of the at-fault notice to evict. For all no-fault notices of eviction, currently the Housing Department is accepting those notices with the filing of the Declaration of Intent to Evict. The Declaration of Intent to Evict, as you recall, is required of all no-fault reasons, such as owner occupancy and compliance with government order. These declarations require that the owner also pay LAHD an application fee for processing of the declarations. Along with the declaration or soon after the declaration is filed with LAHD, the owner must ensure they provide a copy of their no-fault eviction notice to LAHD to be given to their analyst no later than 3 business days after service on the tenant. Another new law that's currently in place is that all landlords are required to post a summary of rental rights at their property. The notice, you will be able to see an image of the notice on your screen. It's a 2-page notice, and it applies to all residential units in the City of Los Angeles, which must be posted in an accessible common area of the property. For example, a laundry room, near their mailboxes, wherever anybody and any tenant can see the notice. All residential units in the City of Los Angeles are also subject to the Tenant Anti-Harassment Ordinance, which has been effective since August 6th of 2021. This ordinance defines and provides examples of what harassment of a tenant may look like. This includes a landlord who takes away housing services, who refuses to make required repairs, who enters the unit without proper notice, who threatens a tenant with physical harm, and there's a series of several other examples which may define and may establish harassment of a tenant by a landlord. If a tenant believes that they have been harassed by their landlord, they can file a complaint with LAHD by calling us at area code 866-557-7368. Once again, that number is area code 866-557-7368. It is important that tenants keep records and notes of any event that they believe indicates harassment, with dates and times, and get statements of neighbors. Of course, if a tenant feels like they are in physical danger, then the appropriate department to call is the LAPD, and if it's an emergency, that would be 911. There are future laws that are anticipated to become effective by the end of March of 2023. The first upcoming law is referred to as the economic displacement, which is when there is more than a 10% rent increase within a 12-month period. If a landlord increases the rent more than 10% over the span of a 12-month period for one unit, for a particular unit, then the tenant has the option to either pay the increase, or they can choose to move out of the unit in exchange for relocation assistance. The relocation assistance amount for a 10% or more rent increase is different than the relocation amounts for no-fault eviction. The relocation amounts for economic displacement are displayed on your screen, and they are based on the total number of bedrooms. So, for example, for a one-bedroom unit, a tenant would be entitled to relocation in the amount of $5,241. If the landlord seeks to increase the rent more than 10%, and if the tenant decides they're not able to afford that rent increase, then they can terminate their tenancy in exchange for the relocation amounts that are listed on the chart on your screen, specifically the second row that's titled Relo amount by bedroom size. Those are the amounts that a landlord may have to pay a tenant if they want to increase the rent more than 10%. Another new law that's anticipated to also be in place by the end of March of 2023 are evictions for non-payment of rent limitations on landlords. Landlords may not evict a tenant who falls behind on rent unless the tenant owes an amount higher than the fair market rent for their bedroom size. The fair market rent depends on the total number of bedrooms in the unit. For example, if a tenant rents a one-bedroom unit and the tenant's current rent is $1,500, the landlord cannot evict that tenant for that amount since the rent owed is less than the fair market rent for a one-bedroom unit. The chart on your screen gives you the 2023 fair market rents for units based on bedroom size, from efficiency units, the ones that don't have any bedrooms, up to 4-bedroom units. If the tenant owes less than the amount of the fair market rent, then the owner may not evict the tenant for that amount of rent. It must be more than the fair market rent. One more thing to add on evictions for non-payment of rent. Because they are based on the fair market rent and on the total number of bedrooms, anytime a landlord serves a tenant a non-payment of rent notice, that non-payment of rent notice must indicate the total number of bedrooms in the unit. Keep in mind that even though a landlord can evict a tenant for non-payment of rent, generally speaking, the COVID eviction protections still apply. Therefore, if a tenant is protected from non-payment of rent because they were financially impacted by COVID, they still cannot be evicted, even if it's more than the amounts located on these charts. If you have additional questions or specific questions about your unit, you may contact the housing department either by sending us an email message at housing.lacity.org/ask-housing, or by calling our hotline at area code 866-557-7368. Once again, that's area code 866-557-7368. Tenants are also able to file a complaint online. We also will be posting this presentation and slides along with additional information at our renter protections website, which you can find on your screen. If you have a hard time finding these websites, you could always Google LAHD Ask Housing to send us an email, or LHD Renter Protections, so that you can navigate your way to these specific sites. We will continue to have webinars and workshops throughout the year on these topics. You may RSVP for these webinars, either by signing up to our newsletter and RSVPing electronically, or by calling area code 213-928-9075. Thank you for your time.